Okay, friends, there's some new reporting on how Donald Trump's lawyers are planning to go scorched earth on D.C. Federal District Court Judge Tanya Chutkan, who has been tasked with holding evidentiary hearings into Donald Trump's democracy-busting January 6th crimes. And Trump's lawyers, get this, are going to try to stop Judge Chutkan from holding those hearings in advance of the November election. They, period, will, period, fail, period. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, I am sick and tired of the never-ending injustice being inflicted on our nation by Donald Trump, as now ably assisted by the United States Supreme Court with their President is King ruling. But you know what? I am so damn glad that we the people have been selected as the final jury standing between Donald Trump and dictatorship. And on November 5th, we will fulfill our duties as jurors and we will vote. We will vote Donald Trump guilty. Now, let's have a look at the recent shenanigans by Donald Trump's lawyers. Here is the new reporting by Hugo Lowell of The Guardian. Headline: Trump plans to block hearings in January 6 case before 2024 election. Lawyers for ex-president preparing to shut down possibility of high-profile officials testifying at evidentiary hearings. And that article begins, Donald Trump is expected to launch a new legal battle to suppress any damaging evidence from his 2020 election subversion case from becoming public before the 2024 election, preparing to shut down the potency of any mini trials where high-profile officials could testify against him. The plans come after the U.S. Supreme Court last week, in its ruling that broadly conferred immunity on former presidents, opened the door for U.S. District Judge Tanya Chutkan to hold evidentiary hearings, potentially with witnesses, to determine what acts in the indictment can survive. In the coming months, Trump's lawyers are expected to argue that the judge can decide whether the conduct is immune based on legal arguments alone, negating the need for witnesses or multiple evidentiary hearings, the people said. If prosecutors with special counsel Jack Smith press for witnesses, such as former Vice President Mike Pence or White House officials to testify, Trump's lawyers are expected to launch a flurry of executive privilege and other measures to block their appearance, the people said. The plans, which have not been previously reported, are aimed at having the triple effect of burying damaging testimony, making it harder for prosecutors to overcome the presumptive immunity for official acts, and injecting new delay into the case through protracted legal fights. Trump's lawyers are not expected to make any moves until the start of August, the people said, when the case is finally returned to the jurisdiction of Judge Chutkan after the conclusion of the Supreme Court's 25-day waiting period and a further week for the judgment to be formally set down. Once Chutkan regains control of the case, lawyers for Trump and for the special counsel have suggested privately that they think she will quickly rule on a number of motions that were briefed before the case was frozen when Trump filed his immunity appeal with the Supreme Court. Okay, friends, A few observations of the latest dirty tricks Trump and his team are contemplating. And the first has to do with the trial court judge, Judge Tanya Chutkan. I have the utmost respect for and confidence in Judge Tanya Chutkan. Why? Well, for openers, I used to try murder cases against her in the courts of Washington, D.C., when she was a public defender and I was a federal homicide prosecutor. That was admittedly decades ago, but I have followed her career while she has been on the bench, while she has been a judge. And, at this point, she has a whole career of honorable public service behind her. And I have a feeling she may just be getting warmed up in many ways. And I've said this before, and I'll say it again because I believe it. Judge Chutkan don't play. Okay, now let's turn to the substance of the reporting about Trump's potential efforts to shut down evidentiary hearings. First of all, it comes as no surprise that Donald Trump and his lawyers desperately don't want witnesses to testify at these hearings that will be conducted by Judge Chutkan. Let's just use Mike Pence as an example. But remember, there are dozens and dozens of witnesses. Many of them are longtime Trump administration officials or loyalists or allies, and they are virtually all Republicans who, provided damning testimony about Donald Trump before the grand jury. It's no surprise Donald Trump and his lawyers do not want those witnesses to see the light of day inside a courtroom. So how are they going to try to shut down Judge Chutkan from holding evidentiary hearings? What trick are they going to pull out of their trick bag? Well, you saw it in the article. They're going to claim executive privilege. Nope. Wrong. Can't do it. Why? Because executive privilege resides with the sitting president of the United States. We've been through this exercise before. When Donald Trump tried to invoke executive privilege, even though he wasn't president anymore, and Joe Biden said, no, I'm not invoking it to help you, Donald. And that will be the same result here. Joe Biden ain't invoking executive privilege to cover up Donald Trump's crimes the way he would like. So the executive privilege dog won't hunt. But let's assume, just for the sake of argument, that for one reason or another, these hearings will be held, but there will not be live witness testimony. There will be other evidence and arguments on that evidence. Here's the thing. Jack Smith has the grand jury transcripts of all of these witnesses who testified about Donald Trump's crimes before the grand jury under oath in an official proceeding. And those transcripts can be marked as a government exhibit and can be introduced at these hearings that Judge Chutkan will hold. And then, once they are admitted into evidence at these hearings, guess what, friends? They become matters of public record. And we all get to see them and read them and pore over them and learn a whole lot more from these Republican witnesses like Mike Pence about the crimes of Donald Trump. And here's the thing. If that's the way these hearings play out, with Jack Smith using sworn statements of the witnesses, like grand jury transcripts, instead of live witness testimony, here's the beauty of it. Donald Trump's lawyers don't get to cross-examine the witnesses. You can't cross-examine a grand jury transcript. So they don't even get to cross, for example, Mike Pence, to try to knock him down or make him look like a liar or make him look like he's got a grudge against Donald Trump because, I don't know, Donald Trump, tried to have him hanged in Trump's criminal determination to retain the power of the presidency after the people, the American voters, voted him out. Trump's lawyers don't even get to cross-examine the witnesses if they succeed in convincing Judge Chutkan. We don't need live witnesses. Jack Smith is not stupid. And I believe Jack Smith will be 3 tactical steps ahead of Donald Trump's lawyers. And at the end of the day, these hearings will be conducted. Donald Trump's efforts to put a stop to the hearings before the November election will fail. And we, the people, who, did I mention up front, we've been selected for jury service, and we will vote come November 5th, and we will vote Donald Trump guilty based on the evidence, not even based on politics, based on the evidence of how Donald Trump tried to destroy our democracy, and he's still trying to do it. So these hearings will be conducted. We will learn a whole bunch more about Donald Trump's January 6th crimes. And that's a good thing. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.